Just a short while ago, the Court of Appeal announced that it had reached a decision that it does not have jurisdiction to entertain the appeal that the Prime Minister and others wanted to present to the Court of Appeal, and therefore they refused the application for an urgent hearing of the appeal.
So what happens now? What is the next step if they decide, as the AG has said, that they are thinking the CCJ?
Well, if they're thinking the CCJ, the procedure is laid out. They would have to get special leave from the CCJ, and the CCJ would probably deal with that as the hearing of the appeal. There's a logistical problem. I mean, it's 24 hours basically. So, I mean, the CCJ has met in urgent sessions like this before, but I think it's really for the government to decide what they're going to do.
So what do you make of the court's ruling and the reasoning?
Well, I think the law was on the side of the respondents. We referred to cases that had already been considered by this court, decisions that have been made by this court. I think Mr. Williams attempted to try to get around the cases that had already been decided by this court. Insofar as this is concerned, what it says is that when you want to make an urgent application to the Court of Appeal, you must come by another way. And it is not for me to advise them of what the proper procedure could have been, but clearly they chose the wrong route.
Senior Counsel, do you think there is any way in hell that we will get to this referendum on Wednesday? Looking at the logistics, looking at the time frame.
Well, I mean, as you heard, one of the issues was that the Chief Elections Officer had told her officers to proceed notwithstanding. I would hope that good sense would prevail and she would now issue an email and say, listen, then come with a left hook, then give me an uppercut, make we chill, because after this, I mean, the CCJ will then just knock them out cold. As I said, we relied on decided cases. I think the law in this area is clear. I think my learned friends were well aware that they had a very difficult case, and in a matter like this, for the CCJ to take it up on an urgent basis and to hear it, it would have to be clear to them that the Court of Appeal has made a mistake, and therefore they will grab it and correct it in time. My sense is that the government would not be able to show the CCJ at this stage overnight that there is such a glaring error by the Court of Appeal that CCJ has to grab it in order for the referendum to be held. And I think it is important that the Belizean people know that there is sworn evidence before the court that the government issued a press release. The Honorable Attorney General also stated that the referendum can be delayed. So mature reflection is what is required. There is no point paying more legal fees. There is no point going to the CCJ over this. The point of the matter is that they came by the wrong route, and I think that we must just accept that and, like the party leader said, hit the pause button.